Okay, I just wanted to talk a little bit about foreclosures, and if it looks like you're going to be heading into a foreclosure situation, or it looks like coming up, you may have some trouble with your finances. I'm going to be reading from some information that I've put together. That anybody that's listened to any of my videos knows that the United States is a corporation. They made you into a corporation by putting your name in all capital letters. I'm not going to go deep into all that stuff right now, but just be aware of it in the background. I have all this information on stopthepirates.blogspot.com. But just know that there are legal remedies that can save your house and free you from the slavery of the banks in the United States Incorporated, the slavery that they want to keep you in. So I'm just going to, because this is going to be a short video here. What I recommend is people read what's called Modern Money Mechanics. I have a copy of this on my blog, but it's easily downloadable on the internet. And in there, you will see that really the banks can't loan money. They don't have any money to loan. They loan credit, and it's your credit. And then they trick you into signing some documents saying you're going to pay them back. But if they're challenged properly, they have to go away. And there's a lot of people having success doing this right now. Let me just... yeah. One thing you want to be aware of is when you sit down to buy your house and you sign the big stack of papers that they bring in, it's not a two-sided contract. The bank isn't sitting there on the other side of the chair going, okay, here's the money I'm going to loan you, and we're signing. This is a two-sided contract. It's not. It's a one-sided contract, and you're the only party to it. Just be aware of that too. There's what's called lack of consideration. Every promissory note written by a bank or finance company is based on deceit. Some of that deceit is as follows: lack of consideration given in exchange for any promissory note. They don't put up anything. They don't. Non-disclosure of all facts regarding the use of the promissory note in your signature. Non-disclosure of the monetizing of the promissory note. Non-disclosure of the bank's relationship to the trustee and beneficiary. Non-disclosure of their lack of authority to foreclose. Forgery of the documents you gave them for safekeeping. And the list goes on and on and on. It's a deliberate practice by the financial institutions to deceive you and keep you as an economic slave in order to keep paying the interest on the credit loaned by the International Monetary Fund. I recommend you start reading the UCS, that's United States Code Title 11 and Title 12. All this stuff you can be pulled up on the internet. And if you're interested in moving forward in this commercial economy that's set up before us, I would highly recommend taking your television set and smashing it to pieces and throwing it away and start to study, because we really have to unlearn everything you've learned and learn a whole new process. And more importantly, teach it to your children. Lack of consideration. Any contract must have consideration to be valid. The note you sign, which the bank monetized and turned into money and put back in their pockets, is not consideration to you. Your exchange amount amounted to a gift to them and change to you. And for your generosity, you were given a bill in the same amount and told you had to pay for 30 years of interest. I have a procedure. It's called the 1099 OID that's out there, and it's for advanced people, but you can actually claim back all that interest and the money that they used to make money off the note that you sign. So lack of consideration. Non-disclosure of the use of the promissory note in your signature. Were you told they were going to open accounts in your name for the purposes of monetizing your note you signed? What they do is they take the note you sign, which is initially like a Federal Reserve note, money, and they put it into a deposit account in your name. And they turn around and write a check. They forge your name and write a check to pay off whoever they need to pay off. And then they give you a bill for the whole thing. So they never actually put up anything. And then non-disclosure of the monetizing of the promissory note. You will never know the process of monetizing the security interest. Non-disclosure of the bank relationship to the trustee and the beneficiary. Most banks own the trustee and beneficiary specified in the contract note. This is illegal and a conflict of interest. Illegal and a conflict of interest. This makes the note in its present form void. Non-disclosure of the lack of authority to foreclose. If you signed a note and it had a government form in it, Form HUD or HUD, it makes the loan under government regulations as to the authority to foreclose. The bank cannot legally foreclose if no commissioner has been appointed by HUD to oversee the foreclosure. Forgery of the document you gave them for safekeeping. When the bank takes your promissory note and alters it in any way, and it's an act of forgery. A simple for deposit only on the back of the note is an act of forgery, and which is what they do. They deposit it. Well, this is not a very good video. I don't know what's going on, but these things are weird. I don't have the best equipment out there. Well, actually, it's pretty good equipment. I just don't have the sun in the background. Okay, so moving on. Interesting note, the Federal Reserve System pays the U.S. Treasury 0.20.6 per thousand notes. That's of a penny. It's not even 1 cent. It's a little over 2 cents each without regard to the face value of the note. Federal Reserve notes, incidentally, are the only type of currency now produced for circulation. They are printed exclusively by the Treasury Bureau of Engraving and Printing, and the 22 cents per thousand price reflects the Bureau's full cost of production. The Federal Reserve notes are printed 1, 2, 5, 10, 20, 50, and 100 dollar denominations. So basically, it's not worth anything. Now, interesting information has come out recently with the RESPA. And in fact, I saw a video today of a gentleman in Pennsylvania, I think, who did an administrative process using the Real Estate Settlement Practices Act and actually foreclosed on a bank because they tried to slap him with a, which happens a lot. They try to put an insurance policy for over the amount of what the home is actually worth and make you pay for it, and if you don't pay it, then they'll go in and foreclose. They're just stealing. But there is remedy out there. The Real Estate Settlement Practices Act, or RESPA, 15 United States Code, Chapter 27, Section 2605 was acted in 1974 by Congress to stop the fraud that was going on against anyone involved with the act of making loans. The very first thing I would highly recommend is to send to your lender a RESPA request. This puts the lender on notice that you think something in their behavior has not been appropriate, and very easy to do a RESPA request. They won't answer it. Okay, so then after 30 days you send them a notice of fault with opportunity to cure, and when that is not answered, you send them a default notice. And it's you have to do a little time in court, but it's really not that big of a deal. I've done it many times and saved a lot of people's houses. Hang on to these letters. It may be important in the future if you have to go to court. Also, send all mailings certified with return receipt requested with the declaration of proof of mailing signed by someone who witnessed you putting the letters into the envelope and mailing it for you. And pay attention to Section 2605 and see what authority the servicing companies have to foreclose. They don't have any legal authority at all. And those are the people that are filing the unlawful detainers and putting up the notice of default against you on your house. Just keep in mind when you signed your note and you basically paid for your house, they tricked you into signing a servicing contract. So what this involves is doing your RESPA letter and then getting you want to get a default judgment against them in court for not responding. Legally, they have to do that per government guidelines. And this is all broken down on my blog, stopthepirates.blogspot.com. And then what you want to do is you want to do a UCC1 financing statement. It's found on the Secretary of State's website. If I were you, I'd get acquainted with all these forms immediately. Also, UCC3 and a UCC11. And I recommend that you do a UCC11 search on your name to see if there's any claim against you out there. UCC3 is an addendum that you can file adding information at a later date. You can also refile your UCC1. Just add the number of the original filing to the form before you send it in. The UCC financing statement is used to give notice that there is a legal separation between you and the flesh and blood man or woman. You have a straw man, it's your corporate fiction that was set up at your birth. And you need to do the UCC1 financing statement to separate yourself from that and show you as the authorized representative, and put you in first position. If there's any any legal action or any money coming in, you want to be in first position. Let's see. So the Secretary of State has all the filing system online for that. And then you want to file an amended promissory note. Anyone can amend their promissory note that they originally signed with the bank. The reason being is it's a one-sided contract which only you sign. So you can change the terms of the note. Things like interest, length of payments, late fees, disclosure requirements, insurance requirements, property tax requirements, and everything. Just file an amended note. It's your note. You can do what you want with it. And take a copy of your promissory note that you originally signed, start going through it line by line, start making notes on the parts that are not fair and not in your best interest. An example of an amended promissory note will be including a sample document. Anyway, I have those sample documents. And you want to replace replacement of the trustee and beneficiary notarized. Replacing the trustee and beneficiary is critical to the success of the slowing down or even permanently stopping a foreclosure. The trustee and the beneficiary are key players in the foreclosure. Trustee is given the power to foreclose and to sell your home, and a trustee's sale or give the task to the sheriff. If you change the trustee to someone you can actually trust, then the bank cannot foreclose on your home without the trustee's permission. It's simple stuff, folks. It's not rocket surgery. What is this? Sorry about the I'm fading out here. The sun coming up behind me. Anyway, and then you want to go and you want to rescind your power of attorney. Filing this document, it's very simple to do. It's actually it's very crucial. In your promissory note, some note somewhere where it is stated that you are giving the bank trustee or the beneficiary a specific power of attorney, you must rescind this so they cannot appoint anyone else that will act in their best interests. And then the RESPA request, it's an important document you must send. In fact, it should be sent at the very beginning. They usually won't answer it or try to appease you by sending in some vague answer at the best that cannot answer any of the questions. Real Estate Settlement Procedures Act is a law passed by Congress. We already went through that. Your UCC3 amendments, A, B, and C, vested interest, security agreement, promissory lien. You do your affidavit of truth. An affidavit of truth is one of the most potent weapons you can use. When made out properly and witnessed by a notary, it carries great weight in a court of law. It is also a poison pill in an admiralty court. If the respondent does not answer point by point to the charges, they are essentially acquiescing to the truth of the document, and then by tacit agreement, they are agreeing to what is being said in the affidavit. I have samples of all this on my blog. And then go into what you can do at post default and how to just kind of sew everything up and put it in a tight little package. Don't ever leave your home, folks. I'm sorry to fading out here, but go to stopthepirates.blogspot.com. If you need to file bankruptcy, great procedures on doing that. And guess what? If you file your UCC1 financing statement, you're going to be the first one that gets paid in the bankruptcy, because you're first in line. Okay, thank you very much for listening. Have a nice day.